Appeal number 123, the people of the state of New York versus Dwight Smith.
Good afternoon, Your Honor. Ramandeep Singh for the people of Bronx County. May I reserve 2 minutes for rebuttal?
You may, sir.
Your Honors, the appellate division here committed reversible error by finding a right to counsel violation after defendant was subjected to a buccal swab based on the consent of his attorney. Defendant's appearance before the court.
How did the court arrive at the conclusion that defendant had consented?
The consent, it was the consent of defense counsel, Your Honor.
Mm-hmm.
This motion was served on defendant and defense counsel on March 12th in court. Mm-hmm. The court asked defense attorney whether he would consent to this motion. Defense counsel stated that he would speak to his client, and the court asked defense counsel to put the opposition in writing if they were to oppose this motion.
And then he was relieved, wasn't he?
Well, so that was on March 12th. On April 30th, defense counsel appeared before the court, and yes, he did ask to be relieved, but the court did sign the order on that day.
Right, but isn't there an affirmed finding by the appellate division that in the interim there basically had been no conversation, there had been no discussion?
Well, it was, I believe it's error, it's error on the part of the appellate division.
That's a finding of fact that they've made, and how would we have jurisdiction to change that finding of fact?
How is that a finding of fact if the Supreme Court never found it? Could that be an affirmed finding of fact by the appellate division then?
Exactly. There was no basis for the appellate division's finding that that defense counsel basically had abandoned his client without any facts on the record.
I have a more basic question to something you said earlier, which was that the defendant is present at the proceeding where the motion is served. According to the transcript, it says that this defendant was produced but not brought down. But then in your brief, it says that the people served on defense counsel with defendant present, a courtesy copy of the motion. So there seems to be a conflict between your representation and what the transcript says. The transcript is on page A124.
Your Honor, later on in that proceeding, it says defendant is now brought forth and present at that same proceeding.
Where is that?
If I may have 1 moment. On A124, it says now Mr. Dwight Smith did appear. That's line 15.
So, counsel, get back to my question,
thank you.
please.
I'm sorry.
On the consent, how did the court arrive at that finding that the defendant had consented to the buckle?
So, Your Honor, defense counsel basically had a period of approximately a month and a half in which to put in opposition papers. In that time period, co-defendant Toby Fair's attorney put in opposition papers. Defense counsel did not put in opposition papers. Even at that proceeding where...
Was this an implied consent based on the attorney's failure to put in the opposition papers, or did he represent that to the court? I'm not seeing that.
Well, at that proceeding, there was a conference at the bench, but from the record, it does seem to be an implied consent based on the fact...
Is that then undermined by when the defendant is produced in front of the judge? He says things like, I haven't spoken to my lawyer. I didn't know about the motion. I didn't consent to this, Judge.
Well, Your Honor, again, the order was based on defense counsel's consent. And at that proceeding, when defense counsel asked to be excused from the case, the people said that we are holding the card for defendant to get swabbed. So clearly, defense counsel at that point was aware that the buccal swab would be taking place. Did not say anything to the contrary.
Do we know when the motion was signed?
We don't know the exact
The order,
time.
I mean, the order was signed.
We don't know the exact time that the order was signed. It seems to be either at that proceeding or earlier that day, based on what the court says, that this morning I signed an order for the buccal swab. But the important thing is that the court had been considering this motion, had been waiting for opposition papers for over a month. So this is not a case where the motion was proposed that day and the court signed it that day.
But if counsel is saying, I want to withdraw because I'm not going to get paid, we don't know at what point that relationship breaks down due to these financial concerns. So it may very well be that, again, counsel and client have had no conversation about this. They've been busy talking about how to get paid.
Your Honor, defense counsel is, there's nothing on the record besides defendant's self-serving statement saying I haven't spoken to defense attorney.
But you would admit that the defendant, in the absence of consent, has a colorable argument that the OCME, I can't tell by looking at the record what day they found the DNA. The 45-day rule here appears to be clearly violated. There may be good cause, but that you would rely on OCME then. And there's no date in the record, so we can't really tell if you had good cause or not, or when it would arise, or how so, if it even would arise. So in that situation, the people appeared to clearly fail the 45-day rule under 240, whatever the subsection is. So how would he not have an argument to make?
Well, first of all, I would say that the people were never given an opportunity to present the good cause argument.
So you're really relying solely on whether or not this is a critical stage of the proceeding. Your position is this has already been decided, that the court's already signed the order, this is done, and now the only question is whether or not he can object to a buccal swab after the order's been signed, right?
Yes, correct. This was not a critical stage of the proceedings. The motion practice that preceded this proceeding.
But the language does appear to be very problematic here in this interchange, particularly in the context of what seems to be a relatively strong argument on the 45-day rule.
Well,
and the consequences for the defendants seem very serious.
Well, again, Your Honor, the defendants claimed that he hadn't spoken to his attorney in over 2 months, and that he didn't know anything about the motion. Those are classic claims that should be addressed via a 440 motion. It's not fair to defense attorney to presume that he abandoned his client and that he hadn't spoken to him in 2 months. So we don't know when their relationship or the payment stopped and their relationship became troublesome. But that's not fair to suppose from this record here. It's important to remember that the only thing that occurred when defendant appeared before the court at that proceeding was the actual swap. The motion was not decided at that point.
So let me ask you this. Let's say the amount of time that elapsed here had not been the time that had elapsed. Let's say it's the next day that counsel comes back and says, I need to withdraw.
Yes, Your Honor.
Right? So would the defendant at that point be able to proceed as he has here, appearing before the judge and arguing, well, I haven't discussed it, I need a lawyer, I object to it, no, I don't want to consent to this buccal swab?
I think he would have a slightly better,
Why is it only slightly?
because here a defense attorney had over a month in which to file opposition papers. It's reasonable for the court, when the court did not receive opposition papers, to conclude that there won't be opposition.
Why would it be reasonable if the defendant is saying, I've not discussed it, I object to it, I don't want to do this, I need a lawyer?
Because there's...
When the lawyer has said, the counsel has said, I want to withdraw because I'm not going to get paid.
But he still has obligations while he's on the case to his client. And without facts that are not present here, we can't suppose that he abandoned his client.
And if counsel doesn't know that the motion's been decided?
I mean, it's clear
The
from...
counsel has no idea the motion's been decided. Does that make a difference?
If the counsel, if he doesn't know that the motion, well,
Go with what your argument is, that the counsel still has responsibilities. But as far as counsel knows, the motion's not been decided, and the court is going to appoint another lawyer, or the defendant will retain a lawyer, whatever.
Well, the prosecutor is standing there saying basically saying we're going to take the DNA swab. I think it's reasonable.
Is that before or after the withdrawal is granted?
That it's before the proceeding is concluded, but after defense counsel has stated that I want to be excused from this case.
I'm sorry, I just don't remember from the record. Is that before or after the court grants the request?
It's before, Your Honor. It's
thank
before. And
Counsel, is defendant's right to counsel honored when given the opposite views of consent? Defendant says, I didn't consent. The court says, your lawyer consented. Is his right to counsel honored when the court engages him in that colloquy about the buckle and actually talks him into submitting to the buckle?
I believe it is, Your Honor, because again, as the court mentioned, the buccal swab could have been taken off the record in the presence of Department of Corrections. It seems to be a courtesy that the court wanted to have the swab done in court, and the court mentioned something about the defendant's arm being injured and wanting to avoid any sort of situation where there's some use of force maybe to take the swab. So it seems to be a courtesy that defendant is before the court, and the court, I believe the court could have worded its a statement to the defendant saying, will you consent to this? I believe the court could have done a better job there, because it's not really based on defendant's consent. The order had already been signed, and the express language in the order says it can be carried out even if the defendant tries to resist.
Counsel.
Thank you.
Counsel?
Counsel, assume for the moment, and I don't know how any of us feels about this, but that we conclude that this was not a critical stage of the proceedings because the order had already been made, and the physical taking of the swab is not a critical stage. Just assume that for the moment. Is it part of your argument here that it was nevertheless an abuse of discretion for the trial court to refuse defendant's request to, maybe he didn't use these words, to grant him an adjournment, to have time to speak with a lawyer before he went forward with this? Is that part of your argument?
Yes, that would be part of our argument, Your Honor. May I just introduce myself? My name is Matthew Bova from Mr. Smith. So, yes, Your Honor, even if this were not a critical stage, you still have the statute 210152, which clearly says that the right to counsel applies at every stage of the action.
Okay, but this is, my question is different, and we may have a debate about whether that statute applies to this particular proceeding, but aside from the right to counsel, the request for an adjournment. I mean, the court said, I'm getting you a lawyer, right? And the lawyer will be here at the next time. So the request just to wait until that next time before the swab was taken. That's my question.
Yes, Your Honor, and I think that really gets, in many ways, to the heart of the matter. I mean, whether you view it as an abuse of discretion in the way that the court dealt with this express request for counsel or a critical stage, the bottom line is we have a defendant here who's appearing before Supreme Court after his attorney has been relieved for non-payment. And he tells the judge, Your Honor, I need a lawyer. I don't know what's going on. My lawyer hasn't spoken to me. We have not had communication. You're telling me now that he's consented. I want to oppose. And at that point...
I'm sorry, counsel, did you make either of those arguments below, either the abuse of discretion argument or the statutory argument?
No, Your Honor. The argument made below was that it was a critical stage, which we absolutely press here because there was a lot of work counsel could have done. Under CPL 470.352B, though, Your Honor, it doesn't matter that a claim was not raised below. When respondent is here before this court, can press any question of law that justifies affirmance as long as does not lead to the granting of affirmative relief, which we are not seeking here, as this court just established and confirmed a longstanding rule in Warrington. So what we have here is a court is looking a defendant in the eye, listening to a request, a plea for an attorney, because he says, I want to put in a motion. And at that point, and as far as I can tell, the prosecution does not contest this. At that point, it is undisputed before this court, counsel could have done work. Counsel could have entered the case. Counsel could have said, Your Honor, I want to put in an opposition under 240.90.
What of the fact that when new counsel came along, that never happened?
Your Honor, that's irrelevant because the critical inquiry before this court is what happened at that April 30th proceeding. When a right to counsel violation occurs outside the presence of counsel, as here, as this court recently confirmed in People v. Garay, preservation is not required. It is not required for a defense counsel after the fact to drudge up a transcript.
I'm not talking about preservation. I'm just asking whether the fact that the new counsel I guess in a way, maybe it goes to harmless error, I'm not sure, but the fact that there was plenty of time for counsel to say, whoa, my client tells me that he never consented to this, that it was never discussed with him, and so I want to move to re-argue, or I want to move to suppress, or whatever style, whatever the counsel wanted to style it as. But that never happened, and there was a fairly long period of time from the time new counsel came in until the end of the case. So does that tell us anything? Is that meaningful in any way? That's really my question.
It's not meaningful, because the only way you could really have a cure of this kind of fundamental violation of the right to counsel is if the prosecutor or the court told counsel and made a record, counsel, on April 30th, 2009, there was a proceeding that was conducted. Your client was insisting on a 240.90 sub 1 motion, and I did not allow for that, and I made him go forward. Counsel, what is your position on this? Would you like to assert a violation? Would you like to reopen the proceeding? That kind of cure would be permissible, but that never happened here. The prosecutor was there at the April 30th, 2009 proceeding. The state had a lawyer. Mr. Smith did not. If the prosecutor wanted to effect the cure that Your Honor is talking about, the prosecutor could have said on May 21st, 2009, when new counsel was appointed, Your Honor, I have problems with what happened on April 30th. I just want to clarify the record, and I want to make sure that we give the defendant an opportunity to cure.
Why would the burden be on the prosecutor to do that?
Well, my point is simply that the defendant doesn't have a lawyer there, but the prosecutor does. If the state wants to effect a cure of the violation, then that's something that can be done. The court can also do it. I mean, whether it be the prosecutor or the court, the bottom line is there needs to be a record confirming that kind of cure, and that's not what we have here.
Would we, if we agreed with you, be making a rule that every time the state performs a particular test, there's a right to counsel? I mean, would you have a right to counsel on every taking of any kind of blood test, just any test involving the defendant for now, say a fingerprint test, a blood test, a swab test? Is there a right to counsel now in all those proceedings?
No, Your Honor. As to the actual observation of the administration of the test.
Well, not the observation, the taking of the test itself. Do you have a right to counsel then?
No, Your Honor. The right to counsel.
Was the purpose of this proceeding anything other than the taking of the test?
Well, Your Honor, the context matters and the record matters, and really
no,
what we're
talking. I agree with you, it does. But I guess what I'm searching for here is why this isn't a 440 as opposed to a right to counsel issue.
Because this is a violation of the right to counsel in that Mr. Smith's right to counsel, his right to counsel at a critical stage was violated. Mm-hmm. And Your Honor, the difference between this case and the mere observation, we're not saying that counsel had to be there to look at the insertion of the swab into Mr. Smith's mouth. That's absolutely not our argument. Our point is that when an unrepresented defendant...
But let me just stop you 1 second. The only time he becomes an unrepresented person if we, by the analysis that that counsel had left already, and and something else happened other than the taking of the swab. Some other decision was made other than that, and that's the analysis we have to buy for that sequence to hold true. I think that's my difficulty with it.
Well, the rule would be simple: when a defendant appears in front of the court without a lawyer, whether it be that the lawyer has already left him and been relieved, or he's represented and there's no lawyer by his side. When the defendant asks the court and says, Your Honor, I need a lawyer because I want to oppose a test that apparently my lawyer has previously consented to, the proceedings stop. The court does something very simple. Says, we'll give you a day, we'll bring the lawyer on, we'll allow you to consult. There was no need to rush. Time was absolutely not of the essence. Instead, what the court did was it heard a request for counsel, heard a desire to oppose a critical, crucial discovery application that totally changed the tenure and totally changed the scope of this entire case.
There's more going on there, isn't there? Because didn't the judge try to persuade the defendant that seeking to challenge or object was futile because the law was against him?
Yes, Your Honor. So not only did the court ignore a request, but the court provided erroneous legal advice. The court told him, you have no argument. And he absolutely had an argument. He had an argument for preclusion, as Your Honor referenced before. He had an argument for preclusion under 240.901. Now, counsel could have come in and said, I want to open this issue up. Before this discovery application occurs, I want to open this issue up. And that did not happen here.
Assuming for a moment that you're correct that an error has occurred, why is the remedy dismissal of the indictment? Why is that the appropriate corrective action?
So several things on that, Your Honor. First, it's important to recognize the appellate division's the appellate division's power to impose corrective action. It has very broad discretion. Under 47020, that discretion is very broad.
Has to be necessary and appropriate to protect the identified injustice, correct?
Yes, Your Honor.
And so is it your position that dismissal of the indictment that took place a year and a half or whatever it was before this whole Sixth Amendment issue arose is the correct responsive action?
Yes, the appellate division rationally exercised its discretionary power to look at this case, to discern an egregious violation of the right to counsel, and to say that under these circumstances, and at A9 of the majority opinion, the court uses the phrase, under these circumstances, the correct remedy is not dismissal with prejudice. It's dismissal, start over again, and allow this case to move forward. The prosecution can
Why
seek...
wouldn't it be appropriate to just say, you know what, I'm going to give you a new lawyer, I'm going to let you put in your opposition to this motion, and you know, let you move to suppress or preclude, you know, the results of the swab?
Two things on that, Your Honor. First, I just want to emphasize, and it's important, and I want to get to Your Honor's question, but it's important as a jurisdictional matter, that all these questions regarding the corrective action are moot, because the prosecution has successfully secured a new indictment. Everything the prosecution is complaining about, everything that it's claiming it lost, it's gotten back. There is no live controversy.
Well, before the people had a plea. That's a little bit different place than where it would be starting from now, right?
Right, Your Honor, but the prosecution's appeal to this court, they're challenging the corrective action. They're claiming that the appellate division...
I understand, but I'm just questioning your argument that it's moot because they can start all over again. That's not where they ended, though.
Well, Your Honor, it's moot because after the appellate division decision and after the prosecution filed its brief before this court, they went before the grand jury and they got a new indictment. So that's why it's moot, because they're saying that they were harmed and they want this court to correct the dismissal of the indictment with leave to represent.
What would be the argument that it's not necessary and appropriate to rectify the injustice to let him withdraw the plea? I mean, I'm a little confused there.
Well,
Which is, I think, what part of this line of questioning is about, but maybe I've misunderstood.
Your Honor, that would have been an appropriate corrective action also, but the appellate division has broad remedial power and broad corrective action power. And what the appellate division said was, under these circumstances, looking at this violation, looking at how egregious it was, that they determined that a deterrent sanction was more appropriate, which is exactly what Wardlaw recognized, the 2006 decision from this court. Special cases call for special remedies. And this court expressly contemplated that the appellate division and this court have the power in order to deter egregious abuse to send a message and say...
Wardlaw was based on Hilliard, though, which took place, and the violation took place at arraignment, and the court specifically found that there was nothing that could be done to rectify the violation that early in the proceedings, besides dismissing the indictment. So isn't that a little bit different?
Well, Your Honor, I mean, that is a different scenario, but the rule from Wardlaw is that in order to deter future abuse, the appellate division has the power to impose punitive sanctions, and that's what the appellate division did, and it was a modest punitive sanction. All they did was say, you're not going to lose this case forever. Go back before a grand jury, represent the case. That was also in the prosecution's interest because it allowed for them to restart the clock. It allowed for them to start the 45-day deadline over, and therefore, actually, what the appellate division was doing was in many ways giving the prosecution a benefit because it allows for them, instead of having evidence secured in violation of the right to counsel, they now have the ability to start the clock over again. And therefore, the appellate division rationally exercised its discretion under 47020 to deter egregious abuse and also to ensure that this would not happen again.
Thank you, counsel. Mr. Singh?
Let me address the remedy first, Your Honors. The most optimistic party in these proceedings, the defendant, even he did not think that dismissal of the indictment was the proper remedy. That was never requested below.
Well, what about this point that it lets the clock start again, which puts you in a good position? or puts the people in a good position.
The people were happy with the plea deal we had, Your Honor.
Well, you're not arguing that, let me just clarify here. Is your position that the appellate department panel would have exceeded or violated or abused its discretion if it had allowed him to vacate his plea?
No, Your Honor. We believe,
So he could have done that. The panel could have done that.
The panel
You're not
could have
arguing
vacated
that
the-
exceeds their authority.
no, they could have vacated the
All right,
pleas
so
here.
then my point is, if indeed it's, I'm asking you, your response to this argument from your adversary, that the reality is that the clock starts again, so you don't even have to deal with the good excuse, good cause problem that you had before.
Well, the remedy of dismissal, Your Honor, in this case,
Yes.
it's problematic for a number of reasons. First and foremost, like I mentioned, it was never briefed below. It was never requested. Second, the people were able to secure a new indictment. In this case, that won't always be possible. This case is now 10 years old.
Right, but they've cabined this to the particular circumstances of this particular case. They're not making a generic rule.
One would hope this is not repeated in courtrooms every day, correct?
Well, again, Your Honor, I think the way that the decision is phrased, I think it creates a precedent for other cases, and I think this court needs to correct that action because, again, it has no relation to the alleged harm here. There's no claim that defendant was not represented at arraignments. The indictment was secured almost a year before the alleged error. There's absolutely no relation between the remedy provided and the harm that was alleged.
If we were to reinstate the indictment, what happens to that second indictment? Where are we?
The people intend to continue with the original indictment, so I believe the new indictment would be dismissed, Your Honor.
On the people's motion?
Yes, Your Honor.
There's a difference in the charges?
Yes, there are different charges, Your Honor, but the people, again, we were happy with the plea deal.
Manslaughter one in the second, but not in the first?
That is correct, Your Honor.
I see, okay.
But again, the people intend to continue with the original indictment. Of course, we are saying there was no error in this case. The defendant's appearance before the court, again, was for the sole purpose of obtaining a buccal swab. Motion practice at that point had concluded, and any claim that defense counsel abandoned his client and failed to make this argument for one reason or another, those are claims that should be addressed via 440 motion, Your Honor.
Thank you,
Thank you.
counsel.